want to thank Ron so much for the PowerPoints. Without this, I believe we'd be sunk without these PowerPoints. And I'll tell you something else. One of the interesting things that I find myself being a part of the last 4 years was an effort initially to do three things. Recognize a need, recognize something that it was an injustice, and to go at it systematically, fairly, and correct it. That didn't happen. The other thing is to be seen and be treated fairly. That didn't happen. And there's 6 of us, 5 of us here. Jim Marshall couldn't be here. But 6 of us, for the last 4 years, have been working with Bob Stein, Tom Ward, and everybody else in their offices, their respective offices, to present, I think, a fair, equitable solution to this real problem. This is a problem that is one of abuse by the National Football League for the last 50 years of ex-players from 1962 when the inception of the NFL came, and I knew Ed Sable. I knew Steve intimately, I knew the family for a long time. I knew what they put into that, and I knew what the spirit was of NFL films. It was to promote the grace of the sport. It's now used as a promotion for a National Football League on a global front. This is where the sport's going. It's going to be moving from here. It's going overseas. It's going to expand. It's going to go global. You're going to get the Super Bowl one day on your cell phone, and it's going to be a global event just like soccer in the World Cup. It's going to be the greatest sport because it is the greatest sport. It's played by the greatest people. And I'll say this, that and I don't wish to be negative. I'm not here to gripe about anything. I'm here to report what happened. It's a big difference. It's a big difference. I am going to walk away from this document as fast as I possibly can. This is a disaster and a disgrace to you. Yes. And the process that went into it is even a bigger story that I'm not going to get into today. But I'll just say this, and I'm surprised at Ron, who I know and I know to be a good man, that you would be a part of delivering this to your brothers is really a surprise to me. It really is. There's a lot of stuff in here, very injurious. You know, there's an analogy in here. It's like if you were coming home from a night out with your family, and you're accosted by robbers, criminals. It's one thing for them to take your stuff and leave you alone. It's another thing for them to take your stuff and then beat you. 2 different things. There's a punitive spirit that's in this document, and when you get into it and take a look at it, how they've not only taken your rights, they're killing you. I can't, as a professional actor and a producer in my business, I cannot be a part of this for that reason alone, but for a moral reason, for a reason of clarity, of honesty. I can't stand up here and say, you know what? There's a couple of things wrong with it. We can bang them out. From the very beginning to the very back is rotten. There's nothing in it. It takes your spirit. It takes your spirit away, and it takes your belief in the system that you go to, and you sit down with attorneys. We sit down with Bob and Tom. I remember we initially met with Bucky Zimmerman, who was our lead litigator. Bob and Tom were assigned as the negotiators. They bifurcated the case that way. We came here, the 6 of us, the 6 original plaintiffs came here to listen to Bucky Zimmerman's direction, being the litigator, his direction towards what would be a surefire way to bring the two sides together, as if we were waiting all this time to be in partnership with the National Football League.
Goal, I'm not real clear of what the original goal was, so if you could clarify that. And then for Ron,
well, let me answer that.
Okay.
And then just go over to Ron.
All right.
The original goal, when Bob Stein called me and said, here's what we're doing, why don't you be a part of this? I'd be more than happy to. We're going to get 6 guys together, and we're going to go at this problem, and what we want to be able to do is establish our value to the league. What are we worth? We got to find that out. And we found it out, but no one was interested in it. And the second is to be treated fairly in the process, which we were not.
Okay, thank you. Ron, you mentioned that you were involved with the NFLPA for a long time, and then there was some disagreement and you moved on, but you set up with the Hall of Famers, so a fund to help raise money so the families and players wouldn't live in poverty. So my question was, why was that not able to be done league-wide for all of the players? Why couldn't you duplicate that, or did you try?
Well, I tried. One of the suggestions I tried to push when I was president of the retired players section was to give us our independent identity, let us have our own trade name and logo, the NFL Players Association Retired Players Section, let us license so we can bring in, earn money for the group. There was simply no interest. Just couldn't do it. It was zero interest. It wouldn't even be part of the discussion.
The players of the league?
No, it wasn't the league. It was the Players Association. The Players Association. We couldn't. They would not allow us to have an independent identity, be financially independent, put a member of the Retired Players Association on the board of directors, maybe a non-voting member. We just we were nothing more than just a hollow unit with no rights and no significant benefits.
And then you mentioned, I believe, is that you didn't think the class action suit on an individual level would be beneficial to the individual player. So based on what the other two speakers have stated, can you articulate if there is, if everybody did sign on, and I saw the presentation, but how does that help the individual player, the retired player?
Yeah, first, everything they said didn't change my opinion. I mean, it's certainly, it is certainly sobering, and I certainly agree with them. I'd like to see far more money, but it's the practicalities of what is possible. And the first step, by the way, Mike mentioned that it's for a jury to find on factual issues. You never get there because it's for a judge to decide whether or not the class will be certified. And it doesn't look like they would be able to reach that point. And so what you're left with is all us having individual rights, with most of us it not being of value. So what do you get? Well, you get an opportunity to set up a foundation. Mike says no guarantees. That's just not true. We absolutely, by law, when you're running a charitable foundation, you must distribute something like, I think it's 80% of the proceeds each year. You're mandated to do it. So we have to set up programs that would benefit retired players. Would everybody of the retired class receive something? Probably not, because it's going to be need-based. But and exactly how the programs are set up, it'll give us some time. We're actually in it probably a shorter time than Mike. The board was just formed, and we have to develop the programs. We have to develop the criteria, but it absolutely will be done.
And to the question that Mike raised about the $50,000, and when I heard the $42 million, I thought it was going to all be put in up front. It looks like it's going to be put in over time.
That's
and then
correct.
With the clawback. So And does the board get paid? And then if you have to hire a director based on this comment with the 50,000, I mean, I'm in business, I own businesses, so it made me wonder, well, you know, there has to be some merit there, or at least we need to look into it. Do you agree with that?
Sure. Well, first let me comment on that, on the 50,000. 50,000 is set aside just to get the various professional entities, there'd be 3 of them, incorporated and the whole process started. It's not envisioned that there will be only 50,000 to run the operation. We also, again, I tell you, the boards are run by the players. We have the right to, in my opinion, if we didn't think there was enough money that's available to run the legacy fund, not the legacy, the licensing agency, that we could move some of the money from the charitable foundation. I believe that would be a possibility. And in addition, there's $8 million that's been set aside for the actual mailing out of the rights to individual people, give them the chance to opt out, the notification of the rights, and payment of attorney fees. The more we can hold down attorney fees, the more we got money to run the agency.
Okay, and my final question to all 3 panels, I'd like an answer. So, Mike, yes, go ahead. Sure.
You said there's no guarantee. I mean, I said there's no guarantee, and you said that that's not true. And I want to ask you if you can tell any player in this room what he will receive, because that's what I said.
Yeah, I heard you.
Okay, if you look at the common fund, which is on page 37, the purposes for which it can be put to. And by the way, if you go back to page 36, it says it's for the benefit of class members who are retired players and other similarly situated individuals. Who are those? Do you know?
I don't know.
Okay.
I don't doubt you the language is there. I just don't know how that'd be interpreted. Except I know that when we enforce that, it's going to be for retired players only.
But
that's
agreement
under our control.
But the agreement says it has to be for retired players and other similarly situated individuals. That's number 1. Number 2, if you go over to page 37 under C, you see that the purposes are for medical research, short-term and long-term housing, health and dental insurance coverage, medical screenings and evaluation, mental health programs, wellness programs, career transfer programs, including employment training and support, and any medical costs not covered under a health insurance policy. Now let's just take those.
Go on, read the whole thing.
It's on page 37.
You didn't finish it.
Well, all right.
Doesn't it say other uses agreed to by the board?
That's a catch-all at the end, okay? Now,
Kind of important.
and the NFL, okay? Provided, see, there's always these provideds. So there's an exception, and then there's a carve-out. So just let's deal with number 1 through number 8. What criteria are going to be used if I'm giving, let's assume I'm a player, and I give up my right. You said some people will get it, some won't. Who's going to get it and who isn't, even though they're all giving up their property right? Because that's the purpose of this. You're saying everybody should give up their property rights, and then these things may happen. Medical research. For example, under this agreement, if medical research is done, Ron, and I don't know if you know this, but if medical research is done, it cannot be used in any litigation against the NHL. In other words, NFL. In other words, if medical research was done into concussions, etc., and it was statistically significant, it was a great epidemiological study, longitudinal, they did it all, grade A medical study, it could not be used in any litigation on concussions. Are you aware of that?
I was not aware of that, but here's the point,
All right,
Mike.
then
Go ahead.
Here's the other thing. For any of these, and that's the point here, is tell these players what it is they are going to get for giving up their right. I'm not arguing the fact that somebody may get something. I don't think anybody's ever argued that. But we have no idea what that is or what the criteria are going to be. And it goes to this common good entity who then transfers it to third-party 501c3s. What are the 501c3 charters of those organizations? Who are they? They certainly, are you going to require them to set up so that they're only for NFL players or other similarly situated people? I mean, that's the whole point here, is that players, what is known is that players are giving up something. What is not known is what they're going to get. That's just clear. And I don't think, Ron, you or any of the lawyers who are proponents of this settlement can say to any player out here what he's going to get. Or to their heirs.
I can tell you that we're charged, the board of directors is charged with the duty to provide programs for the retired players. And we're charged with the duty to do it in good faith and with the best of our abilities. And we're charged with the duty to set up the criteria for each of these. It hasn't been set up. The board's existed for, I don't know what, but 2 weeks, 4 weeks. So, well, please, let me finish. So we have to set it up. And when it's set up, it's got to be fair. It's got to be reasonable. I don't know which one of you will qualify. We haven't set up the standards yet.
Right. So that's my point. You don't know.
The NFL Disability Board is also charged with the duty, and look what they've been doing.
Well, let's stick with this first.
Well, please.
Okay, my final question.
Don't equate us with that.
Let me just answer the other part of it.
I've had many fights with the NFL Disability Board.
Let me answer the other part of what Mr. Hawkins asked, and that is and you responded, well, the $8 million, we might hold down the attorney's fees. First of all, the $8 million, $50,000 was for the license, and I'd really like to talk about this licensing agency, but $50,000 for the licensing agency, $450,000 for administration, sending out notice, just to get the settlement done, that's what that's for. And $7.5 million is set aside for attorney's fees. So are you telling the folks here, you're going to say that the lawyer should get less than $7.5 million? And you're going to fight for that?
Absolutely.
You are?
Absolutely.
Okay, and is the rest of the people going to do that?
I think the board is with me on that.
Okay. And who did...
I'm sorry. Well, you probably should get on the line.
How can you trust the board if the original 6 people, y'all kicked into the family? What kind of damn trust is that?
Well, first of all,
6 people that started this were kicked to the curb, and you've never given a reason why they were kicked to the curb.
well, first of all, I did not kick anybody to the curb.
Never kicked them to the curb, never gave an original reason why they were, and then you call it acceptable, and now you say trust that group?
And try to settle without them knowing?
That's like me fighting for you.
like Judas up
That's like me fighting for you. I get money, I fight for you. And when the fight's done, you say you bring in somebody else and they take credit. That guy put his name on the line. Those people put their name on the line and you kick them to the curb and you can't give a reason why you kick them to the curb.
I can tell you what my understanding is of what the process. I can tell you my understanding. No, let me finish. I listened to you. I can tell you my understanding of what the process was. My understanding of what happened was that the judge supervising the case, because there was a conflict between the lead counsel, the lead attorneys, wanted to see if there were more people interested in the class to join the class as lead plaintiffs, and that's how they got included. That's my understanding.
If they wanted to join, they had an opportunity when those guys started. If they wanted to join, it's just like all the Bible says. When you first started fighting CTE, what the hell was everybody else? When those guys first brought this up, they had an opportunity to join in. And now you're telling us to trust a John Hunt Lately? And you're telling us to trust an NFL? Let me say this to you. The truth is generally seen and not heard. You want us to hear you. These people want us to see them.
Okay, so final question. I'd like for all three of you to answer.
Sorry, Frank. We're being very rude to you. Go ahead.
All right. So current players are getting 45% of the NFL Films revenue. So is there an opportunity in this loss, or should there be, at the very minimum, that from 92 back, that all retired players to create another fund and they participate in that fund? That's a question.
I'm sorry, who was that for? I'm sorry.
I didn't understand the question.
So you guys mentioned NFL films. And in the current contract with the current players, who are all going to be retired sooner or later, they're getting 45% of the revenue from NFL films. I think Mike said that. Is that right, Mike?
Yes, well, there's three buckets that are funding the CBA. One of the buckets is the revenue from NFL films, and 45% of that goes to fund the CBA. Yes.
So my question goes to what Fred says, and in his acting, if you use his likeness, you need to get paid. And I think NFL film started in 1962. So from 1962 till 2000, whatever the number is, 2 or 3, that isn't spoken to. And Fred says, then I'm opting out. You can't use my likeness and not pay me for it. So my question is, at a minimum, with this going forward or not, should retired players be paid for the using of their likeness?
Well, yes. The short answer is yes, in my opinion. Okay, but what's important, Frank, is that there be a model developed for damages, which I don't believe has happened. There is a value that can be placed on NFL films. Economists and others can put a value on it. You can look to other surrogate proxies in the marketplace. You get experts to put a value on that. That type of discovery has not yet been done. And to me, and it goes back to what I said, is that this is a team sport. Ron is right when he says that many of the players will have very little individual value, so the cost of going forward is prohibitive. But that's not what this is about. This is about the NFL film footage, which is an asset that the NFL has, and it's been built on the backs of the players. So it has some value. What is that value? And then you take that into account in evaluating your damage, potential damages in the case, plus the potential liabilities. And I never said that this is a slam dunk case. There are issues. And when I was up there, I said, you may lose. You may lose on certification. There's no question about that. But the point here is that there has not been the development of that damage aspect, and nobody, and I think Ron has acknowledged here today, and I give him 100% credit for his goodwill and his good faith and all that kind of stuff. I don't want to get into that, frankly. But he cannot say, and he acknowledged that, what any individual player will get. But yet, everybody is asked to give up their rights, and the NFL at the end of the day gets the NFL films unimpeded by any claims coming back, if everybody agreed to this settlement. That's the point. Okay? So, yes, the answer is yes to you, but it's more complex than that. Okay? And by the way, there's no assurance that the court will accept the damage model. But if you do it within the law, it becomes a jury issue.
Good afternoon. I'm Ron Pritchard, 9 years in the National Football League. Ron, thank you for your presentation. Mike, thank you for your presentation. I don't know you two gentlemen very well. Mike, I haven't even met you, but I like what you have to say. Fred, I've known since 1968. He's my bro. And I want to say in front of all my other brothers in football, Elvin, all you guys, I opt out today. I'm not going to follow that deal. That's a bad deal. I'm not stupid. That makes me feel stupid. So I opt out. Somebody write it down. I'm done with that deal.
Hello. I'm opting out too right now. And I have a question for, how did we come to a conclusion of compensation for using our rights, using our film to gain them a multi-billion-dollar business, and then only thing we get back is what you put on the board? They making billions of dollars, and then we don't get anything as far as cash in our hand. We need to get paid too. I mean, we've been working for free long enough. So that's my thing.
That was to me.
The fact that my question, maybe I got off because I'm a little nervous here. I'm shy. Okay, yeah, the compensation for films. How do we get from compensating? I would think if you're going to compensate somebody, you're going to give them money in their hand. How do we go from that to getting these charitable groups that we're going to give the money to when we need the money ourselves? How you come up with that? I don't understand it.
Yeah, but
But
first of all,
Yes, sir.
I didn't come up with it. This was something that the judge determined felt it was the only practical way to resolve the case and the only practical way to give a benefit to the group. Now, he felt that because he felt, and I think the case law supports, that the ability to prove damages on an individual basis is extremely difficult and in most cases unlikely.
why would it be so difficult? We all were out there performing, and we were all used in any type of advertisement to promote the league from day one to now, and it's been their number one way to promote them, to advertise the league. So we pretty much promoted the league to be a multi-billion-dollar industry. We don't have a dime to show for it. We're suffering.
Man, I agree with everything you say.
Well, what you gonna do about it?
Well,
You
I'm
gonna
just
sit up
telling
here
you,
and BS us all the way through?
it's not BS.
I mean,
It was
to me, it
BS.
sounds like BS. Everybody else in here does too.
Well, I don't know if that's so, but it's not BS. But what we're looking at is what is the value of the lawsuit? What can it sell? What can the value of the lawsuit? Will it be successful? My opinion, the judge has already told us the class will not be certified. If the class is not certified, then you're in the unholy land of each individual trying to prove up a claim.
How many of these type of cases have you represented before?
Oh, I've only worked on a few.
So you really don't know then. Where's Hausfeld and the other guys supposed to be doing all the work for us? They're not even here to represent what they're doing for us?
Well, I don't have to have worked on a case to be able to read what happened in the Major League Baseball case. They lost. They did not get certified. I don't have to work on a case to read what the judge said. The judge who was in charge of this case said that he did not believe the class would be certified.
Is that the federal judge or the magistrate judge?
That would be the trial judge. The trial judge said it. So now, if that's so, then what you're really doing is saying, all right, if I can't have my way and get more than 50 million, then I'll take nothing. And I think that the 50 million can be used to help a great many players and help the families of a great many players.
How 50 million? We've made them a multi-billion-dollar business. You're going to put 50 million away, give it most to charity in the lawyers' pockets, and then we're supposed to go away feeling satisfied?
No, of course you're
I
not.
might as well
gonna be
pull my pants
satisfied.
down now, huh?
No, you're not going to be satisfied. I understand that.
Well, let me just say one thing, Ron. The Major League Baseball case was distinguished by Judge Magnuson. So that's number one. A court is required to make a decision based upon the record before him or her. And the record is what's developed, the evidence. And in this situation, in my judgment, and this is my opinion only, that record has not yet been fully developed. So to make a decision that it's highly doubtful it will be certified, that is only based on the record before the court at the present time. Secondly, the law is very clear that you have to benefit the members of the class when they give up a constitutional property right. And that is not happening here, and you acknowledge that yourself. There's no question, by the way, and so everybody here is clear on this from my opinion, that a part of a settlement that provided for some of the things that are set forth in this settlement would be appropriate. But you need to know whether you're entitled to it or not. And that's what's lacking in this settlement. So don't you think, Ron, that you should know the value of the asset, the value of NFL films? Because, for example, you said Jim Brown. I mean, Jim Brown's really given up a lot. Jim Brown ain't given up squat in this. Because Jim Brown, under the licensing agency, can still go out and license himself personally. He doesn't have to take part in the individual publicity rights. I mean, it's right in the agreement here. So he's not giving up anything.
Well,
and if what you're saying is true, that all the stars, only the ones who were quarterbacks or wide receivers, maybe an occasional linebacker, quarterbacks, etc., they're the only ones that have any value. That goes. You've just made, in my judgment, you've made the point that I'm making, and that is that this is a team sport, and the asset is the NFL films, which is used to promote economically this league. And it's been built on the backs of the players. And each of you have an undivided interest in that NFL films. Now, how it's, whatever number is come up with, then you'd have to evaluate. And here's my point, is that let's assume that there is it's doubtful that it would be certified as a class. But one of the things you have to look at is, what is the asset worth? So you may, let's just pick a number. Let's say that the NFL film library is worth $1.5 billion. Okay? Now you look at that, and you look at the liability side of it. Because when you evaluate a case, you look at both liability and damages. So maybe then you might come up and say, well, maybe a settlement here because it's doubtful, but we may get certification. Maybe it's worth $300 million of the $1.5 billion. Maybe they should pay $5 million for the next 40 years. There's all kinds of things that get into the equation then if you fully develop your record. And that's not what's been done here. That's my objection to this proposed settlement. There is no benefit that any of you can say is going to go to any of these players. Some will get it, but you're asking all of you to give up your constitutional property right. And I don't think a Court of Appeals is going to affirm something like that.
You don't think Court of Appeals would what?
Would affirm something like that.
Well,
That's my opinion as a lawyer. Now, I can be wrong on that, but that's my opinion.
You've tried cases before, right?
I've tried a number of cases.
Hi, my name is Susan Marshall. I'm married to Jim Marshall, one of the original plaintiffs. And my question is to Mr. Mix. From my read of the settlement, there is something called a service award for the plaintiffs that agree or don't oppose the settlement. Can you talk about that and how much those individual plaintiffs are going to receive for supporting the settlement?
well, I don't think, my understanding, my understanding.
These folks didn't hear the question. The question was, my understanding is that there is a service award or a payment to the plaintiffs who agreed or will agree to settle. So the original 6 have been in for 4 years. There were 3 added about a year ago, and then 6 months ago or so, there were another 9 or 10 that were added. And my understanding is that they will receive a service award. And what is the service that they are providing, and what is the award that they're going to get?
Let me tell you my understanding only. Those who are considered lead plaintiffs are entitled to some type of an award. And that would include the original 6 plus the added 3. And it would probably be based, it's up to the court, it would probably be based on the amount of time that they've served in that capacity. I don't know what it would be.
Don't they get a service award only if they're supporting the settlement?
That's the language, is only if they support the settlement.
That I don't know, but I don't think so. I think they would get an award whether they supported the settlement or not. They were lead plaintiffs.
And there's been no discussion on what that amount would be?
Not to my knowledge. I think that's for the court to set.
Thanks.
Okay, let's take a break.
Can I have one kind of point of order very quickly?
One point.
Mike, just to state the kind of obvious that's sometimes lost, what I'm hearing is you want to continue fighting for these guys. Is that right?
Yeah, we represent the 6 original plaintiffs, and we're going to continue to fight for those 6 original plaintiffs.
What happens to the other lawyers if this deal blows up?
The other lawyers? I don't know. If the deal...
Can you give us a summary where we're going to go here regardless of the merits of
Well, and you should consult with a lawyer on this. Let me just tell you that because I'm not representing you, but the agreement provides that you have up to a certain date to either object and stay in the settlement or opt out of the settlement, which means you're out and you preserve your right to go forward. That date is August 30th of this year. There will be a hearing on the final approval, and that hearing is on September 19th of this year. The court will then issue an order as to whether he finds approval of the settlement or not. Those who object to it, who are still in the lawsuit, can then have a right of appeal. They could appeal, which would go to the 8th Circuit Court of Appeals, to have a review of Judge Magnuson's decision, whatever it is. Okay? And that will take time. So when one of the factors they say about this settlement that supports taking this is that there will be a delay if the case goes on. Well, obviously there will be. But what each of you must make a decision on is, I am giving up a property right, and what is the benefit that is coming to me to give up that property right? And then those who opt out have a right to go to a lawyer and continue with an individual case, or there may be an opt-out class. I can't predict what will happen down the road. I can only tell you that we're representing the 6 original plaintiffs. Okay.
All right, thanks a lot.
Where do we sign up if we want to opt out? How do we do
that? You're going to get notice in the mail, and that will describe for you what you have to do. And it's in the settlement agreement here, but you have to do certain things. If you're objecting, you have to state the reason for your objection and other things. It's in the settlement. And if you're opting out, you have to give your name and other factors. But that'll all be in the notice that you'll receive, which goes out May 30th, I think it is. So you'll be getting a notice early June. And so you have the option then of objecting and staying in. Yeah, or, as my partner points out, you could just accept it. So you accept it, you're in agreement with it, you object to it and stay in, or you opt out. Those are going to be your options.
It'll all be on the blog, so just, and it'll all be laid out really simple, so.
I just got a last question. I thought we were going to continue after the break. It looks like we're not, right?
Yeah, yeah.
This would be it.
I've been asked to break it off, so,
Okay, I can get my question in afterwards, if you'd like.
No. Now go ahead, and this will be the last question.
All right. My question has always been kind of around the rights of the player if the league can block any kind of opportunities for the players. Here's what I liked about the fund or the agency was that I almost started from the standpoint of, let's just forget the past. I'm willing to forget the past if going forward I get to go down the yellow brick road or the golden brick road, and create opportunities for players to do the things that we want to do, whatever they are. But if those things are going to be blocked, or if there's nothing that says we're going to get that opportunity, in other words, there's no language in there that says the NFL will use their best efforts to help us, or they'll use their reasonable efforts to help us. Because one of the things that is a huge concern to me is that one of the real reasons I supported this and continue to support it, because as far as I know, that we're going to get that kind of support. As soon as I get any wind at all that we're not going to get that kind of support, then I'm going to start scratching my head and wondering what the hell I'm doing.
Okay, that's a very good question. I'm glad you asked it, because that goes to the licensing program, which I said I wish there would have been some questions on that so Ron and I can discuss it. And that's contained at page 29 of the settlement agreement. And if we could just have a couple minutes.
Sure. Thank you.
There's, first of all, they list group publicity rights. So on a non-exclusive basis, and subject to any agreements you might have out there already that you've entered into, you can give to this licensing agency the right to market, promote, and license class members' group publicity rights as defined in the agreement, until and unless you withdraw your name saying that you're approving this. Okay? So you can say, yeah, I want to be in this group publicity right, but if you want to get out of it, you can withdraw your name. All right? And group publicity rights means two things. It means the single licensee of the player identity elements of a group of class members where either one, the use involves player identity elements, and remember I described those before, it's your appearance, your voice, you know, etc. So involves player identity elements in game footage and includes the player identity elements of at least 6 class members. So as Ron was saying, on a regional basis, if, in my example, be the Minnesota Vikings, if 6 of them wanted to get together and license NFL game footage to someone and get a fee from that, they could enter into that, but that licensee then has to go to the NFL, and the NFL has to agree to it. And in agreeing or not agreeing to it, the NFL is going to apply, in good faith, the same standards that it ordinarily employs in deciding whether to grant license for that type. So, because the NFL retains all the rights in the NFL footage. So even if you set this up, there's a second step. And there's no guarantee that they're going to do it or not do it. And I suppose, look, I can speculate, but let's assume the NFL is doing the same type of thing with another sponsor, and they've licensed it. And maybe that sponsor has an exclusivity. The answer is going to be no under that circumstance. So you really don't know whether this is going to be, whether there's going to be any revenue generated from this or not. The second group publicity right is for any use not involving game footage, but involving IP rights, other intellectual property rights of the NFL, which are also being licensed by an NFL party in connection with such use. Now, this is very convoluted language, but what it seems to be saying, and I'd love to know what Ron's take on this is, seems to be saying that if it doesn't involve NFL game footage, but other NFL IP rights, and the NFL is doing it for that use, well, then you can do that so long as you get the NFL's approval. And such use involves the player identity elements of at least 50 class members. So I guess that's his example of the 1963 Chicago Bears. But what is the NFL doing with regard to the 1963 Chicago Bears? Are they doing it? And is that required or not? I don't know under this agreement, and I don't know.
Well, in every agreement, there's a imposed obligation to act in good faith. It's called good faith and fair dealing, and that is the exact basis that the players won a lawsuit against the Players Association, because they took all of your signatures and put you on group licensing, and then they didn't do anything with them. So you didn't even have to prove damages. They showed that because they didn't do anything, they breached their obligation of good faith and fair dealing. And you remember they got a judgment was gotten of $29 million. So the NFL has got to exercise good faith and fair dealing. But now, obviously, no, please let me finish. Obviously, if we're trying to go to Coca-Cola, for instance, and say that we want to endorse your product, or we want to go to, say we're going to, I think their Pepsi is their sponsor, and we want to go to Coca-Cola, they're very likely going to say no, and we would expect that to say no. But there's plenty of opportunities out there, we believe. Can it be guaranteed? Do I know what they are right now? I don't, of course not.
Do you know what the standards are that the NFL employs in ordinarily deciding whether to grant license for that type of NFL IP rights?
Well, believe me, we'll look at if it gets approved and if this works. we will look at any time that they refuse us, they better have a good reason.
But that's my whole point, Ron, is that's the pig in the poke argument. You're asking, they have to give up their rights here, and you're saying, well, if they do something in the future that we don't like, we'll ask why that is. And there is no best efforts. And that's a very good question, because best efforts is different than will apply in good faith the standards that it ordinarily employs in deciding whether to grant licenses. And by the way, that it ordinarily employs can change from time to time. And they have the absolute right to do that. So that's the group part of it. And then this licensing deal also involves that you can assign your individual rights. Well, I don't know how many licensing agencies there is out there right now. You can do the same thing today without this. You don't need this. And under this, if you give your individual rights, and even if you did it with some sponsor, you still got to get the NFL's approval, and you can do the same thing with some other licensing agency. But under this, if you do it, then they look at the revenue, they take off the expenses, and they can't have more than 15%. So what's ever left of that, you get 75% of the 85%, and 25% goes to this common fund, which then goes back into these third-party charities, which you don't know what they're going to do with it. So. Another very good point. One of the reasons that, we're involved, we're objecting. Now, I'm not suggesting that the NFL is going to do this, but sometimes what happens in cases like this when there's a lot, and I cannot, and I want you to know that I'm not doing this. I want this very clear on the record. I cannot encourage, suggest, or do anything to tell you to either object or opt out. So I'm not. That's up to you to make those decisions. But many times, I can tell you what happens in these types of matters, is that if there are a lot of objectors, or there's a lot of opt-outs, people go back to the table and they negotiate a better deal. In good faith. And,
all right.
So that is a possibility. I'm not suggesting that would happen, but that is a very good question, because that many times does happen. But I don't know how you do that without knowing the value of what's been created by the players. Because let me just say one thing. I know we're using up a lot of time, but this is a very important issue for all of you. And let's assume that NFL Game Films was about the coaches. I'm surprised you're not laughing all of you. I mean, what would that be worth? Squat. Maybe a little bit. I mean, what were you going to do? You're going to put, Vince Lombardi and Bud Grant and a few others in there? I mean, Hank Stram, This game is about the players. That's what it's about. It's built on their backs, their blood, their sweat, their creativity, their athleticism, their grace, their brute strength, all of that. They built it. They built this asset. And that asset has a value. And unless and until you determine what that value is, I don't know how you negotiate and determine whether or not the settlement is fair or not. Even assuming that it's difficult to get certification. Because that's one of the elements. You got liability and you got damages. Ron wants to say the only thing you look at are your individual damages. That's not how that was created. There wasn't one player who created NFL Films. It was created by all the players. Every single one on the team. And how that's determined, how you get paid or anything else after, that's another thing of negotiation. So, to me, unless and until you find out what the value of the asset is, I don't know how you say it's fair. Now, what's happening here, in my opinion, is that people say, well, we got a difficult case and you may not certify, so let's take what we can and we'll do this common good fund, etc. And some of you may get a benefit. But you don't know if you are going to get it or not.
We sure appreciate the enlightenment, and thank you very much.
Boom 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 boom